Philippine environmental policy in establishing an environmental impact statement system, including other environmental management-related measures and for other purposes. Under Section 1, the policy of the state is to create, develop, maintain, and improve conditions under which man and nature can thrive in productive and enjoyable harmony with each other. Second is to fulfill the social, economic, and other requirements of present and future generations of Filipinos, and to ensure the attainment of an environmental quality that is conducive to a life of dignity and well-being. The goal of PD 1151 is to recognize, discharge, and fulfill the responsibilities of each generation as trustee and guardian of the environment for succeeding generations, assure the people of safe, decent, healthful, productive, and aesthetic environment, to encourage the widest exploitation of the environment without degrading it or endangering human life, health and safety, or creating conditions adverse to agriculture, commerce, and industry, preserve important historic and cultural aspects of the Philippine heritage, attain a rational and orderly balance between population and resource use, and improve the utilization of renewable and non-renewable resources. It shall be the duty and responsibility of each individual to contribute to the preservation and enhancement of the Philippine environment. All agencies and instrumentalities of the national government shall prepare, file, and include in every action, project, or undertaking which significantly affects the quality of the environment a detailed statement on a. the environmental impact of the proposed action, project, or undertaking, b. any adverse environmental effect which cannot be avoided should the proposal be implemented, c. alternative to the proposed action, d. a determination that the short-term uses and resources of the environment are consistent with the maintenance and enhancement of a long-term productivity of the same, and e. whenever a proposal involved the use of depletable or non-renewable resources, a finding must be made that such use and commitment are warranted. PD number 1151 and PD number 1586 require all agencies and instrumentalities of the national government, including GOCCs and private corporations, firms, and entities to file the EIS for every proposed projects or undertakings that significantly affects the quality of the environment. The DNR is the government agency vested with delegated powers to review and evaluate EIA reports and to grant or deny ECCs to project proponents.
Nature and stages of environmental impact assessment or EIA process. EIA is a process that involves predicting and evaluating impacts of project, including cumulative impacts on environment during construction, commissioning, operation, and abandonment. Stages of EIA process. Screening determines if the project is covered or not by the PEISS. Second, scoping. Scoping identifies the most significant issue or impact of the proposed project. Third is the EIA study. Involves a description of the proposed project and its alternative, characterization of the project environment, impact identification and prediction, evaluation of impact significance, impact mitigation, formation of environmental management and monitoring plan. Fourth is the review of EIA report. Entails an EMB procedural screening for compliance with minimum requirements specialized during scoping. Fourth is decision-making. Involves evaluation of EIA recommendations and a draft decision resulting to the issuance of ECC, CNC, or denial letter. Lastly, monitoring, validation, and evaluation assesses performance of the proponent against the ECC and its commitment in the environmental management and monitoring plans. Next are the nature of EIA. EIA is not a document but a process that involves evaluating and predicting the likely impact of the project. Next is the signing of Statement of Accountability or SA is necessary for the validity of the ECC. The law governing the ECC was PD 1586 do not specifically state that lack of signature in the SA has the effect of invalidating the ECC. Letter C. A separate Environmental Compliance Certificate or ECC is required for additional removal or replanting of trees affected by expansion of a mixed-use tourism project. Next, prior public consultation and approval of local government units for national government project is required. In case of Bangus Fry Fisherfolks versus Lanzanas, the court explained that the Congress introduced Section 26 and 27 in the Local Government Code to emphasize the legislative concern for the maintenance of sound ecology and clean environment. However, in this case, the court held that Section 26 and 27 do not apply because the petitioner admits that the mooring facility subject of the case is not environmentally critical and hence does not belong to the 6 types of project mentioned in the said provision of the law.
Under DAO 2003-30, Environmentally Critical Area or ECA is defined as area delineated as environmentally sensitive such that significant environmental impacts are expected if certain types of proposed projects or programs are located, developed, or implemented in it. Such program must undergo an EIA to evaluate and predict the likely impacts of all stages on the environment. Under DAO 96-37, an ECC applicant for a project within ECA must submit an initial environment examination which must contain a brief description of the environmental setting and also must submit a certificate of locational clearance or zoning clearance. Although Section 5 of PD number 1586 or environmentally non-critical projects provides that environmentally non-critical projects shall not be required to submit an environmental impact statement, it is still expected to provide additional environmental safeguards as deemed necessary. Section 59 of the EPRA law reveals that ECC is an indispensable requirement before a conduct of an environmentally critical project or implementation of a project in an environmentally critical area. It does not follow that ECC is a license or permit in the mentioned law. Section 3 of PD number 1586 requires that all EIA reports be submitted to the NEPC or now the DENR for review and evaluation. Pursuant to Section 4 of PD number 1586, ECCs are issued only by the President of the Philippines or the duly authorized representative, which is the DENR. Article 9 of DAO 96-37 complaints to nullify an ECC must undergo an administrative investigation, after which the hearing officer submits his report to the EMB director of the regional executive director who will render the decision. Aggrieved party may file an appeal to the DENR secretary.
Policy Declaration under PD number 1586. The decree declares as a policy of the state to attain and maintain a rational and orderly balance between socio-economic growth and environmental protection. It establishes the environmental impact statement system founded and based on the environmental impact statement required of all agencies and instrumentalities of the national government, including government-owned or controlled corporations, as well as private corporations, firms, and entities, for every proposed project and undertaking which significantly affect the quality of the environment. Presidential Proclamation of Environmentally Critical Areas and Projects. The President of the Philippines may, on his own initiative or upon recommendation of the National Environmental Protection Council, by proclamation declare certain projects, undertakings, or areas in the country as environmentally critical. No person, partnership, or corporation shall undertake or operate any such declared environmentally critical project or area without first securing an environmental compliance certificate issued by the President or his duly authorized representative. The PENRO is tasked to monitor the project's proponents' compliance with the conditions stipulated in the ECC, with support from the DNR Regional Office and the Environmental Management Bureau. HLURB has a more specific monitoring duty as the sole regulatory body for housing and land development. It is mandated to encourage greater private sector participation in low-cost housing through liberalization of development standards, simplification of regulations, the centralization of approvals for permits and licenses. RA number 7611, known as the Strategic Environmental Plan for Palawan, is a comprehensive framework for the sustainable development of Palawan, compatible with protecting and enhancing the natural resources and endangered environment of the province. It shall serve to guide the local government of Palawan and the government agencies concerned in the formulation and implementation of plans, programs, and projects affecting the said province.